The Supreme Court courtroom buzzed with a quiet tension that seemed to hang in the air like a storm about to break. For years, the evidence pointing to systemic voter suppression in Jefferson County had been laid bare: detailed reports, statistical analyses, witness testimonies. Yet courts had consistently turned away, unwilling or unable to confront the reality. But today was different. Today, Congresswoman Jasmine Crockett stood before the nation's highest court, ready to force the justices to face the uncomfortable truth. "These disenfranchised facts," Crockett began, her voice steady, resonant with conviction, "have been consistently presented to courts over the years. What has been missing is not the evidence itself, but the willingness to recognize what this evidence clearly shows." The courtroom, grand and imposing with its marble pillars and lofty ceilings, fell silent. Crockett's words rippled through the room, challenging the justices to look beyond legal technicalities and confront the reality of voter suppression happening under their watch. Justice Stoa, a longtime advocate for voting rights and a quiet supporter of Crockett's position, leaned forward, absorbing every word. But the majority of the court wore expressions ranging from polite skepticism to barely concealed impatience. Suddenly, the county attorney rose, his usual confident demeanor replaced by a nervous edge. His eyes flickered briefly toward the gallery before fixing on the bench. "Your Honor," he said, voice shaky but resolute, "those statements, if authentic, do not represent the county's official position." His attempt to distance the county from the incendiary remarks seemed transparent. "They do represent the actual motivations behind these laws," Crockett shot back quickly, not missing a beat. "And under this court's own precedents, from Washington v. Davis to Village of Arlington Heights, evidence of discriminatory intent is crucial to any equal protection analysis." At the back of the courtroom, Chief Justice John Roberts, who had been leaning back with a faint smirk just moments ago, suddenly straightened in his chair. The faint chuckle that had escaped him at the start of the session was gone, replaced by a solemn nod of recognition. This wasn't just another argument. It was a direct challenge to the core principles of the court's voting rights jurisprudence. The mood shifted palpably. What began as a seemingly uphill battle against a skeptical and somewhat dismissive bench had transformed into a profound moment of reckoning. Justices who had seemed indifferent or critical were now leaning in, visibly engaged. Those who had supported Crockett's views from the beginning found themselves with newfound, concrete evidence to strengthen their stance. As Crockett advanced her closing points, her voice took on the weight of history itself. The right to vote is not merely another legal issue. It is the foundation upon which all other rights in our democracy rest. When we allow that right to be undermined through technically neutral but practically discriminatory measures, we betray the promise of equal citizenship enshrined in the 14th and 15th Amendments. She paused, then fixed her gaze directly on Chief Justice Roberts, the man whose initial laughter had cut through the courtroom like a blade. "Mr. Chief Justice, you once wrote that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. I respectfully suggest that the way to stop discrimination in voting is to recognize it when it occurs, even when it comes dressed in the modern garb of election security." A hush fell over the courtroom, the gravity of her words settling like a heavy fog. Roberts himself inclined his head slightly, acknowledging the powerful turn she had given to his often-quoted statement. It was a moment few expected, a rare glimpse of vulnerability and reflection from the court's leader. "Thank you, Congresswoman," Roberts said, his voice low but measured. "You've given this court much to consider." As Crockett returned to her seat, the gallery erupted into whispered astonishment. Legal observers exchanged knowing looks, reporters scribbled furiously. In less than half an hour, Crockett had managed to shift the entire dynamic of the case. What once seemed a likely defeat now shimmered with the possibility of a landmark victory for voting rights. Outside the courtroom, the impact of the hearing rippled through the legal community and media. CNN's legal analyst Jeffrey Toobin called it one of the most remarkable turnarounds in Supreme Court history. Meanwhile, Fox News judicial correspondent Shannon Bream acknowledged, regardless of where you stand on the issue, Congresswoman Crockett's presentation was a masterclass in constitutional advocacy. Civil rights leaders, who had expressed pessimism before the hearing, cautiously embraced a new hope. Reverend William Barber, too, told reporters, "Today we saw what happens when truth confronts power directly. The outcome remains to be seen, but truth had its day in court." Congresswoman Crockett, however, remained measured in her public remarks. "This isn't about me or any individual victory," she told gathered reporters outside the Supreme Court steps. "This is about whether our Constitution's guarantees apply equally to all Americans, regardless of race, income, or zip code. I'm hopeful the court will affirm that fundamental principle." Behind closed doors, the hearing's impact was even more profound. Sources close to the court revealed that the justices held an unusually long and intense conference following the arguments, far longer than the typical brief sessions. Chief Justice Roberts reportedly led a deep, hours-long discussion focused on the evidence Crockett had meticulously presented. 2 weeks later, something unprecedented happened. The court ordered additional briefing on specific aspects of Jefferson County's voting procedures, a clear signal that several justices were re-examining their initial stances in light of Crockett's compelling arguments. The weeks following Congresswoman Jasmine Crockett's historic Supreme Court argument in Jefferson County v. United States were marked by an extraordinary ripple effect that shook the very core of American voting rights jurisprudence. What had seemed an uphill battle, facing skepticism and even laughter from Chief Justice Roberts at the outset, now began to reveal itself as a profound turning point, with repercussions felt not only within the hallowed halls of the court but also across the nation's political and legal landscape. Legal experts and analysts scrambled to digest the seismic shift Crockett's presentation had triggered. Jeffrey Toobin, CNN's legal analyst, described it as one of the most remarkable turnarounds in Supreme Court history. His commentary captured the disbelief that had permeated the legal community: how, in less than an hour, a seemingly insurmountable case had been reshaped by a meticulous presentation of facts and constitutional principle. Across the ideological spectrum, even Fox News judicial correspondent Shannon Bream acknowledged, regardless of your stance, Congresswoman Crockett's advocacy was a masterclass in constitutional law. Behind the scenes, the court's reaction was unprecedented. Sources close to the justices revealed that the post-argument conference stretched for over 3 hours, an unusually long time given the court's typically brisk procedural gatherings. Chief Justice Roberts, who had initially greeted Crockett's arguments with a dismissive chuckle, now led a rigorous discussion dissecting the compelling evidence of discriminatory intent and disparate impact presented. For the first time in years, the court's conservative and liberal wings found common ground in their concern over modern voter suppression tactics cloaked in seemingly neutral language. 2 weeks later, signaling the court's unresolved questions and shifting stance, a rare order was issued requesting additional briefing on specific aspects of Jefferson County's voting procedures. This request sent shockwaves through legal circles, signaling that several justices were reconsidering previously held positions and that the court might adopt a more fact-intensive approach to voting rights challenges going forward. Then, 3 months after the argument, the Supreme Court issued its ruling in a stunning 6-3 decision. The majority coalition was surprising. Chief Justice Roberts sided not only with the court's 3 liberal justices but also with Justices Barrett and Kavanaugh, creating a majority that decisively struck down several key provisions of Jefferson County's restrictive voting laws. Roberts' majority opinion read as a transformative manifesto on the evolving nature of voting rights law. He opened by acknowledging the court's prior jurisprudence, stating, "While this court has traditionally emphasized that not every voting regulation imposing some burden on voters demands strict scrutiny, we cannot ignore substantial evidence indicating that certain provisions were crafted with discriminatory purpose or have a disproportionate effect on citizens' voting rights based on race." This admission was significant in itself, but Roberts' recognition that voter suppression tactics had evolved was the core revelation. Voter suppression, much like other forms of discrimination, adapts to circumvent legal constraints while retaining its essential discriminatory character. When the court is presented with clear evidence that ostensibly neutral provisions are applied in discriminatory ways, it cannot and will not turn a blind eye. This language signaled a doctrinal evolution, reshaping how courts must analyze voting laws by requiring comprehensive, contextual fact-finding, scrutinizing legislative history, statistical impact, and implementation to uncover discriminatory intent or effects. Justice Stoa, who had consistently championed voting rights, wrote a powerful concurring opinion lauding the empirical evidence and historical context Crockett had painstakingly assembled and presented. This decision underscores the critical need to bring forward concrete, specific evidence demonstrating discriminatory impact and intent, Stoa emphasized. The detailed comparative analysis offered during oral argument provided the essential lens to understand the nuanced realities of modern voting restrictions. Legal academia erupted with praise. UCLA Law's Professor Richard Hassan called it the most important voting rights ruling in a generation, while Harvard's Lawrence Tribe highlighted how Roberts' reasoning marked a profound shift in the Chief Justice's thinking on race and voting rights. Tribe predicted the ruling would reshape constitutional law and civil rights jurisprudence for decades. Beyond the court, the ruling galvanized voting rights organizations nationwide. Armed with this new legal framework, groups filed challenges to similar laws across multiple states, invoking the court's fresh guidance to contest discriminatory practices masked behind procedural neutrality. State legislatures that had been quietly drafting new voting restrictions suddenly faced renewed scrutiny and resistance, altering the political calculus in numerous state capitals. At the federal level, Congress responded with bipartisan resolve. Senators introduced the Equal Access to Voting Act, a landmark bill incorporating many principles enshrined in Roberts' opinion. The act established uniform federal standards for early voting, voter identification, and maintenance of voter rolls, concretely addressing the very problems illuminated in Jefferson County. For Jasmine Crockett, the case's impact was career-defining. From an under-recognized freshman congresswoman, she emerged as a nationally celebrated civil rights advocate. Law schools invited her to deliver keynote lectures on constitutional advocacy, civil rights organizations sought her counsel on litigation strategies, and even political adversaries in Congress acknowledged her newfound authority and respect. The court's ruling translated into tangible progress on the ground. The subsequent election saw an 18% increase in voter participation in Jefferson County, a remarkable surge largely fueled by communities historically marginalized and disenfranchised by previous restrictive laws. Margaret Wilson, an elderly resident who had been turned away from the polls under the old regime despite voting consistently for half a century, captured the ruling's human impact. "Today," she told a local reporter, "I felt like a full citizen again. I felt seen." The story of Jefferson County and the courageous advocacy of Jasmine Crockett reaffirmed a timeless truth. While legal battles are fought in courtrooms, their ultimate purpose is to empower citizens, protect the sacred right to vote, and uphold the very foundations of democracy. In the months that followed the Supreme Court's groundbreaking ruling in Jefferson County versus United States, the reverberations of the decision were felt across the country in ways that few had anticipated. The 6-3 majority opinion, authored by Chief Justice John Roberts himself, marked not only a pivotal moment for voting rights but a profound evolution in the court's jurisprudence, a recognition that voter suppression, like other forms of discrimination, can hide behind ostensibly neutral laws while perpetuating inequality in practice. For Congresswoman Jasmine Crockett, the impact was both immediate and transformative. Overnight, she became a nationally recognized leader in the fight for civil rights, hailed by activists and legal scholars alike for her meticulous evidence-based advocacy and unwavering commitment to constitutional principles. Invitations arrived from prestigious law schools eager to hear her recount the case, and civil rights organizations sought her expertise to shape their litigation strategies going forward. Even members of Congress who had once been politically opposed now acknowledged her with a newfound respect, understanding that her argument had done more than win a case. It had reshaped the national conversation on voting rights. During a keynote address at Howard University School of Law, Crockett reflected on the emotional and intellectual challenge of confronting the Chief Justice and the conservative majority. Facing Chief Justice Roberts in the Supreme Court was intimidating in every sense, she admitted to an audience of aspiring lawyers. From the imposing architecture to the solemnity of the setting, it felt like standing on a precipice. And when he laughed at my arguments early in the session, It was a moment that could have shaken anyone's confidence. But Crockett's resolve was rooted in a lesson her mother had instilled in her from a young age. Jasmine, your truth doesn't become less true just because someone powerful refuses to hear it. That truth, the lived experiences of thousands of disenfranchised voters, the statistical and historical evidence painstakingly assembled, was her greatest strength. I knew the Constitution was on my side. I knew the facts were on my side. And most importantly, I knew the people who had been silenced by these laws were on my side. She stressed to the students the indispensable role of preparation and evidence in advocacy. I didn't sway the court with rhetoric or passion alone. It was the rigor of the data, the clarity of the historical context, and the undeniable patterns of discrimination that compelled even the most skeptical justices to listen. That's the power of truth grounded in fact. Yet, she also offered a broader lesson about democracy itself. Our legal system acknowledges that even courts can err. That's why the adversarial process is vital. It's not just about winning arguments, it's about illuminating the truth so the law can better serve justice. The court's decision introduced a new framework for scrutinizing voting laws, one that demands courts look beyond mere formal neutrality and probe the real-world effects and historical contexts of legislation. Roberts' opinion acknowledged the reality that voter suppression often adapts to legal challenges while maintaining its discriminatory core. When presented with clear evidence that facially neutral provisions are being implemented in discriminatory ways, Roberts wrote, this court cannot and will not look away. Legal experts hailed the ruling as the most consequential voting rights decision in a generation. UCLA's Richard Hazen described it as a seismic shift that reorients the judicial approach to voting rights, while Harvard's Lawrence Tribe emphasized the profound evolution in Roberts' legal thinking about race and voting, remarking that it could influence constitutional law for decades. The broader effects of the decision rippled quickly. Voting rights organizations across the nation filed lawsuits challenging similar laws, citing the Jefferson County precedent. State legislatures reconsidered pending bills that could restrict voting access, fearful that they would invite legal challenges they were now less likely to win. Congress responded with renewed urgency. A bipartisan coalition of senators introduced the Equal Access to Voting Act, a federal bill establishing minimum standards for early voting, voter ID, and voter list maintenance, incorporating many principles articulated in Roberts' opinion. For ordinary voters, the decision was more than legal theory, it was a restoration of their voice. In Jefferson County, voter turnout surged by 18% in the next election cycle, with historically marginalized communities showing remarkable increases. Margaret Wilson, an elderly woman who had been repeatedly turned away despite decades of voting, told a local reporter, "Today, I felt like a full citizen again. I felt seen." Reflecting 1 year later, Crockett remarked that her confrontation with Chief Justice Roberts was emblematic of a deeper truth about American democracy. What happened in that courtroom wasn't just about the right to vote, though that right is fundamental. It was about the courage to stand up to power and speak truth even when that power mocks you or tries to dismiss you. When asked if she was intimidated facing the Chief Justice, especially after his early laughter, she answered candidly, "Absolutely. The Supreme Court's very design evokes reverence and even fear. But my mother's words echoed in my mind. The truth does not diminish because it is inconvenient for those who wield power." Her final message to the students and the nation was a call to active citizenship. Democracy isn't automatic. It demands our participation and the willingness to hold our institutions accountable. The right to vote is the foundation of all other rights. When that right is denied to some, our entire democratic project is imperiled. The room erupted in applause, not just for the legal victory, but for the reminder that democracy depends on people who dare to challenge injustice, armed with facts, conviction, and respect for the law. The story of Jasmine Crockett and her historic showdown with Chief Justice Roberts stands as a testament to the power of truth confronting power, to courage prevailing over skepticism, and to the ongoing work of making America live up to its founding promises. As Dr. Martin Luther King Jr. famously said, "The arc of the moral universe is long, but it bends toward justice." Crockett's journey reminds us that the arc doesn't bend on its own. It bends because people like her put their hands on it and pull, insisting that America become the country it promises to be.